Yep. Okay. Go!
Will you hand me my screen box?
Now go.
Court does call the case, People versus David Epps.
Yes, to my left.
Other side.
Oh, right. Sorry.
Your name, sir? Thank you.
Well, I'll just start. We've been here previously. I thought we were coming for preliminary examination and relayed that to my client. He has discovery, but in the meantime, he got a second case on the same complainant. That has caused this to be converted, in my opinion, to be
A second case on
the same, calling from the jail. Allegedly, everything's allegedly.
the
Calling
witness,
from the jail.
right?
Okay,
you picked up
everything's alleged.
right.
So that caused a second case, and in my opinion, a second PCC. So we want a preliminary examination for everything. The people have advised me that they will go forward with or without the witness. I explained all this to my client. He exploded. So
What?
exploded. Well, so I didn't know what I was doing.
Okay.
So, and not fighting for him. And that bothers me more. They can tell me I don't know what I'm doing. That annoys me. But when they say I'm not fighting for them, that goes to my core, since I come from a fighting family and I fight for everybody.
Oh, you do.
No, that just is making me talk to you. I am going to fight, but I got to fight within the rules. And I feel I know them a little bit better.
Counsel, I'm just trying to figure out, he told you weren't fighting for him?
Oh, for sure. And a lot more too.
Okay.
Yes, that's why I want to just express myself.
No, yeah, that's fine. You know, it's kind of funny to me when defendants sit up there, they're in custody, they find themselves in more trouble because you were trying to set this, you were fighting for them, you were fighting at me a little bit with this thing, and then has the nerve to say to you, you're not fighting for him, when the reality is, at least allegedly, he's doing the stupid thing that's making your job harder. So that's fine. That's the way he wants to look at it. And the other thing is, and it just amazes me with some defendants, they come up here, they complain about their attorney, and they don't even realize the jewel that they may have representing them, and also don't realize, you know, that fight is it wasn't quite anything you did. It's just in your blood.
Thank you.
It is your heritage.
I was carrying.
He doesn't understand that. He doesn't understand that you got to play by certain rules. He just wants to do it his way. So if he wants to do it his way, we'll do it his way. It's not going to turn out real well. So what do you wish for me to do, Ms. Ford?
I'm asking that we set this for a preliminary examination, that you hear from the prosecutor and my client understand that I am really putting forth a top effort. And along with fighting, I actually have skill. So I hope that he understands that.
Well, he also needs to understand that there's going to be a motion for them to proceed by forfeiture, I'm presuming. And that's going to make your case whatever it is. And I know your counsel will be ready to go forward. I know the prosecutor will be ready to go forth. But you understand that, Mr. Epps?
I understand everything.
Okay. Then let's set.
In case so she does
Right.
not have discovery.
Correct.
So
Just so the court's.
he has discovery on the first one.
On the first case, but not on the
Yes.
second case.
Correct.
How many, there were phone calls, so how many phone calls are we talking about? Because he's gonna have to see all of that, go through it all, so I wanna make sure he has time, so we're not hearing a complaint about that.
As long as possible, within reason.
Yes.
It has to be reasonable.
You didn't have to explain that when I asked you what they going on without the victim.
Oh, excuse me. Let me put this on the record. I did explain that I guess it's hard to understand the various exceptions to hearsay and how in certain instances they can go forward without the victim. I was trying to explain, and then the people gave me a case I haven't read, but I was trying to give him the site People versus Only 27 Mishap 319. Will the court please explain to my client certain instances where they can go forward without the victim? Excited under its mental state, it's.
There are exceptions to the hearsay rule. Given that this is a domestic violence case, there's a statute which would apply, which would allow them to proceed with police testimony. Also, and I don't know if this is the people's intent, they would file a motion to proceed by forfeiture, meaning that because of, the simple way of putting this, because of your wrongdoing, the alleged victim is not present. So the people would, in that instance, not be punished by what is your behavior, or at least allegedly your behavior, Mr. Epps, and so would be allowed to proceed. That's kind of a nutshell version. I mean, there are a little bit more technicalities to it, but I think that
One of the technicalities would be MCL 768.27C, and as I indicated, that case, People versus Only 327, Mishap 319, and the various exceptions to the hearsay rule. That might be excited utterance, present sense impression, mental state of mind.
yeah, I mean, it's all of that kind of thing.
Do I got a right to cross-examine my accuser?
You know what? Here's the thing, sir. That, if you're talking about the right to confrontation, there's a statute particularly on point where that may be forfeited because of what is alleged to be your behavior. That was the last thing that I brought up.
What do you mean by that, sir?
I am not here to give a law school class, although I could. I'm not, I know, but I'm just saying that is very technical. That's why you have an attorney.
But I couldn't explain it anymore, and that's why I brought it up.
You just broke down law school for her. How am I different?
I didn't break down law school.
Okay, I'll tell you.
She asked the
We
question.
have told you.
All right, I'm done. I'm going to set it for exam.
I'm going to go to the jail today, so I will. I'll tell you.
Preliminary examination in this matter, because the
Yes.
people may have a motion. I'll set it for September 17th, 2020.
Okay, just one moment, please. Just. Yeah, don't turn your back on it, please.
September 17th, 2024,
Yeah, but he might be if you like.
9 a.m. That's before me.
Thank you.
When?
September 17th at 9 a.m. Oh, wait a minute, excuse me.
Why so long? That's 3 weeks.
Yeah, September 17th, I can do that, but not the 8th, because that's the judge's calendar, and I'm a deferred professional. There are some parameters, and you are not being. Oh, that's the new thing in the jail I'm learning, that I'm being.
And I would anticipate the people's motion, so we'll try to hear that.
The new buzzword in this world, and everything is a violation of that.
Of what?
Speedy trial. That is the new buzzword in the.
That has.
Can I ask a question? What is about what's going on in the jail? Speedy. None of this particular about my case.
You just said you had a right to
like
speedy
this.
trial.
I didn't say. I asked why so long. I didn't say nothing
It's
about.
not a violation of speedy
I asked why so long. I didn't say nothing about no speedy trial. Like Judge Sim, this is where we having a conflict at, sir. I'm asking about my case, and it's everything other than the case. I don't want to talk about nothing but this case.
Okay, but Mr. Epps, hold on, slow down. You have two things now which have, hold on. You asked me a question, but you're operating off of a premise that isn't gonna work. So here's the thing, you had the one case come up. We then had the hearing, there were allegations made, and this is where the complication comes in. There are allegations that are then made that there is phone contact and other communication. I don't know for sure. The allegations have been made. There's evidence of the phone calls. So that's where we are. What the problem then that happens is that leads to additional charges, which then not only is there now this additional felony, that clearly will have an impact upon what the first case that you came. That's what counsel's trying to get through. She's got to get that information. That then leads to other things.
Okay, I understand that. She's not explaining that, sir. That was simple things to understand.
I accept.
Okay.
We're good.
I can't get in between every counsel and attorney and defendant.
Thank you.
And I'm not trying to do that. I'm just trying to explain the process, and I've got to, Mr. F, I've got to be fair to both sides, so I got to have it worked out. You would have had an exam before now, had this not come up.
That's understood.
Okay, so that's the reason for the stretch out in time.
Okay.
Also, the other thing, so that you just understand, it's not anybody trying to delay anything. Because of the allegations that come with that, and sort of this complicated thing, I won't say it's complicated, but it's a thing where they're going to proceed, presumably, and I don't know if they know this for sure, without the witness. Your counsel has to try to do some things. I've got to give her time to do that for your protection.
Okay.
So it's not trying to stretch anything out. I'm just trying to make sure everybody has an opportunity to do what it is they need to do. It's really as simple as that.
Thank you.
Can I say one more thing, sir? Yeah, my last court hearing that I will be able to get a hold to her when y'all took my phone.
Excuse me?
At my last court hearing, y'all took my phone. Y'all told me I'll be able to get a hold to her. I'm not able to get a hold to her.
You should be able to call your attorney.
We've talked,
I'm not able to get a hold to you.
I don't.
but we talked.
That,
Somebody else phone.
Oh, he's saying he had to go in the three-way, but we talked.
I'm not able to call her, sir.
you should be able to contact your attorney.
I'm not able to, sir.
Well, did somebody at the jail make sure that can happen? Ms. Ford, check into that if you.
All right.
I'm
Yeah,
done here, folks. Bond continue.
Thank you.
Court calls the case of the people versus Michael Horn.
Deborah Jordan, on behalf of Michael Horn. This is a happy story.
Oh, you don't want me getting after him?
No.
No, okay, I'm just asking. I'm just trying to be helpful. Your name, sir? Thank you.
He's asking for a preliminary examination.
All right, and I'll discuss.
He doesn't
What?
belittle me, and he listens, and he calls his probation office, what's it? Tether, I call probation, but Tether agent Josh Bennick, I've spoken with him. He cooperates, wants us to know.
Wow, it's funny how that works out better when you do that. I don't know. And it's interesting, when you kind of do that, he's out. The other guy, I don't know, something.
He is asking though, for one thing, while I remember.
Oh, now he wants me to see.
Yeah.
I knew it. And anyway, go ahead.
But he really, everything I said though was accurate. He would like bond permission. I call it tether to go look for work from 6 a.m.
Okay, hold on. Let me first do this.
No, excuse me, 8 a.m. to 6 p.m. Right.
Hang on. Let me first deal
Sorry.
with studying the exam.
Okay, sorry.
Okay. So would the people have their witnesses available the 3rd?
We'll do our best.
I know I have a major exam about Chester Hill.
What about the 10th?
The 3rd is fine. We'll do our best.
I can't,
So would the 10th work for you?
We'll do our best.
just a minute.
So
Is it
I'm taking
possible-
that as a yes.
As far as I know.
Oh,
Sorry.
Is it possible to put it on the same day as the other case?
Get to choose.
Is that too much?
Okay, I'll put it there, but you may be before another judge, because you don't get to choose that either. So, I mean, it's just gonna be, it will likely, okay, look. Let's just do this. Before I give a date, what is your other request with the tether?
Oh, from 8 a.m. to 6 p.m. that he could look for work.
Who is that? Blanche? Is that Blanche? Oh, that was you? It was Blanche? Yeah, it sounded like a Blanche sneeze, because she interrupted the court like 8 times the other day. Okay. Do the people have a response on the request to go look for work?
I will say I'm a bit confused why he needs to get Heather to go look for work for that large of a time span, if he had an interview set up or if he had employment already. I would be more inclined. But he's out on a PR with home confinement, and we requested 250,000 cash or surety in this case because it is a firearm case. Because of prior CCW from 2023, there's a CCW, PD, and ABK, and the and that was all up here. It's about the defendant texting threatening messages to his ex-girlfriend, showing up in a car, pulling up alongside her, punching her multiple times, and this is after threats. He then grabs a gun, points it at both the victims before leaving.
Okay, so here's what I'm gonna do.
May I say, just respond before I do by a little bit? Okay, he indicated he was not convicted on any gun case, but more importantly, people do murder and get out, and they.
Not here, they don't.
Well,
I don't know where you've been. No, okay, look, here's the thing. Here's the thing. I'm gonna give you your exam date. I'm not changing anything regarding bond.
Okay.
Okay, I'm just gonna leave everything where it is currently.
Okay.
Okay, so what date did you need, counsel?
Thank you. September 17th.
Preliminary examination in person, September 17th, 2024, 9 a.m. before Judge Valvo.
I'm sorry, Judge who?
Valvo.
Okay, thank you.
Bond will continue. Thank you. Here it is in there. Court does call the case People versus Robert Half.
What the fuck? Does any of this look like that? They can't talk.
I think this is your person.
Hey, excuse me, I want to tell you that bring your sweet little fake red rock down here so I can beat it out of fucking niggas,
Yeah. All right.
bitch.
Here, I know that we don't need him to give his name.
Oh, shit, like red,
Okay, so
Lord Brown,
say something.
Lord Brown, the chief public defender, a fighter for his clients.
All right, so what are we doing in this case?
Does the court have an updated report? This is a competency report.
I do not have an update. Well, I do have something from August 9th.
I think that's the most updated, Your Honor. That's the most updated.
And indicating that he still remains incompetent to stand trial.
Your Honor, I'm not surprised at that finding. And I would ask that we set a new
Review date. I can do that. So I'll set a competency review date for November 21st, 2024 at 9 a.m.
Thank you.
Bond will continue. Thank you, Mr. Hatt.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is an interpreter.
I need an interpreter when I cannot express myself somewhere.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're gonna start bringing people in first. We're gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
No taste. Trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.